Charles, we opened the hearing on HB 2354, and we were looking for a description from the reviser.
All right. Thank you, Chairman, members of the committee. House Bill 2354 deals with requirements with respect to withholding of dues for public employees and professional employees, that is, in the state employees who belong to the state employee union and the teachers who belong to professional employees organizations. So this is a bill that last year, this was HB 2586. It was heard by the committee, this committee, and passed out, but subsequently died in committee. It was also on the Senate side, Senate Bill 361. There was a hearing on that bill and a committee report recommending that the bill be passed. Eventually that was, there was a motion to strike it from the calendar, and that was adopted. Turning to the bill, one of the things that the bill does is provides for both professional employees and public employees the right to immediately cease withholding of dues upon submission of a written or emailed request to with respect to professional employees of Board of Education, and with respect to public employees, of course, their public employer. Either the Board of Education or public employer provides notice to the organization and ceases immediately the withholding of dues. The boards of education or the public employer are to provide notice to the professional employees or public employees of the right to cease payment and to withdraw from the organization on an annual basis. The authorization for withholding of dues is not to exceed 1 year, and it is subject to annual renewal. There are specific form requirements for authorization by a professional employee or by a public employee of withholding of dues from their paycheck. There are specific language requirements advising the employees of their right not to join or financially support the union. The form approved in the case of professional employees, teachers, this is a form approved by the Secretary of Labor. In the case of public employees, this form is approved by the Public Employee Relations Board. The employer must confirm authorization for dues withdrawal after the employee submits the form. So there is confirmation of authorization after the form is submitted. Other changes you see in the bill basically are conforming amendments to these provisions. And that is what the bill does.
Any questions for reviser? Representative Highland.
Thank you, Mr. Chairman. Charles, please clear up for me. I remember, when was it, 2014 or 15, we passed a bill that I thought did this very thing.
Representative, I would have to go back and research that. I don't recall that, but I can look into that.
It specifically prohibited the holding of the state paying for anybody's dues be paid to any organization, period.
I don't recall that. I'll have to look into that.
Please do. Thank you.
Any other questions for the reviser? Any online? Seeing none. Thank you, Charles. We'll open the proponent section of the testimony, and we'll start with Vincent Vernucio. I think he's online.
Thank you, Mr. Chairman, members of the committee. Thank you for giving me the opportunity to testify here today. I wish I could be there in person. My name is Vincent Vernucio, and I'm a senior fellow at the Mackinac Center for Public Policy, and specifically the Workers for Opportunity Project. We are here in support of HB 2354 because it simply codifies what the Supreme Court said that states should do in the Janus versus AFSCME decision. And going further than that, it's simply about good bookkeeping. So I know you're all familiar with Janus versus AFSCME, the landmark 2018 U.S. Supreme Court case that basically brought right to work to public employees across the country. That's a right that both public and private sector employees in Kansas have had for a number of years. But the decision actually went further. And what we're going to be talking about here today with HB 2354 is that second part of the decision. The second part of the decision is where Justice Alito said that in order to have money taken out of an employee's paycheck or basically have anything paid for, to a union, that employees have to give what he called evidence of affirmative consent. And he actually went further and said clear and compelling evidence of affirmative consent. And that's what we're talking about here today. Rather than go through some of these wonky terms, essentially I like to call it opt-in. What this bill does is it simply requires the evidence from the employee going directly to their public employer that they want to be a member of a union and they want money taken out of their paycheck. When you boil this bill down, that's simply what it does. But there are many safeguards that we just went through that are baked into the bill. First, once again, that affirmative consent, that opt-in, has to come directly from the employee to the employer. We've seen examples around the country of unions simply sending an Excel file, just sending a list saying, these are people that said they want dues taken out of their paycheck, so take money from them and give it to us. The bill says no, that affirmative consent, that opt-in, has to come from the employee directly to the employer. And then just like when you sign up for a bank account or even an email list, you get that confirmation saying, did you really mean to do this? Just to confirm. The bill provides for that. That's just extra added safeguard to make sure employees really want to opt in and pay dues. And actually, this is in response to several cases on the West Coast where we've seen forgery on union authorization forms. Now going to the form itself. It informs public employees that now they have not just a Kansas right, but a First Amendment constitutional right to choose whether or not to pay a union. So it just informs them of their rights, asks them for that direct opt-in. And then the next step would be that just like other constitutional rights, so think Miranda rights, that once you waive your Miranda rights, that waiver expires over time. This bill simply says that public employees are afforded the opportunity to re-up that dues deduction authorization on a periodic basis. And this is something that attorney generals all over the country that have looked at the Janus decision has said is necessary. It has to be that clear and compelling evidence. It has to come directly from the employer. There has to be something to inform public employees they have the right to pay or the right not to pay, and that should be reauthorized every so often. I believe this bill it's yearly. And then going further, it says that public employees have the right, that First Amendment right, to opt out at any time. We have examples of dues authorization forms that say that you can only get out during the month of August. We've also seen other forms that are even worse, that basically it's tied to the anniversary date of your hire. In fact, not just that, it's like 2 weeks prior to 3 weeks prior to your anniversary date. So essentially you need a calendar and a calculator to choose to figure out when you can stop paying. So this has that annual re-up you can get out at any time. Essentially it has open enrollment, just like many other forms of paycheck deductions have open enrollment, informing public employees of their rights and making sure that it came directly from employees. It's simply about good bookkeeping. It's about a periodic decision. And frankly, now with COVID and with all the economic uncertainty that we're seeing around the country, even if a public employee, if their job is safe, maybe their spouse's job is not, they need to be given a fresh opportunity to make that decision. And that's another reason why this is so important, and it is so important now that we give them that periodic option and inform them of their rights. In closing, this is simply codifying what the Supreme Court said in the Janus versus AFSCME decision. It's something that boards and attorney generals and others across the country have seen, and that is the heart of the bill. So with that, I would be happy to take questions. And once again, thank you for your time.
Committee, any questions? Representative Clayton.
Thank you, Mr. Chair, and thank you for being here today. I was not on the Commerce Committee in the last biennium, so I wasn't here when we heard this bill last year or 2 years ago. So do forgive me if I just, don't quite know everything. But can you tell me about the Kansas cases that are pertinent here in regards to Janus? Because I just don't know. Can you help me?
Yeah, absolutely. So I know that last year it was presented. I'm not sure if it's presented there today, but there was a Kansas National Education Association form that was presented that did not inform teachers of their First Amendment rights, and also had the language, and I'll read it right now. This authorization is to continue in full force unless revoked by me for the succeeding membership year by giving written notice to that effect by my local association on or before August 10th. So essentially, it was delaying those First Amendment rights until August.
Okay, and so who was the person who brought that lawsuit, though? Or are you just reading from something that you disagree with? Or I want to know, specific.
I am reading from the Kansas National Education Association 2019 to 2020 active professional/ESP membership application.
Okay, so it's an application that you don't like, but no one actually brought a lawsuit. That's what I want to know.
It is a dues checkoff authorization form that
okay,
seems
so the
to
answer
violate...
is no. Thank you.
Representative, I believe that this is a preemptive bill to avoid a lawsuit over that exact form, is what he's trying to say before you cut him off.
Okay,
Thank you, that's enough.
there wasn't one.
Any other questions?
I will add that there are public interest law firms and there are lawsuits across the country. I'm not aware of one in Kansas. So Kansas obviously has been lucky so far, but other states, there are several pending lawsuits from public employees who feel that their Janus rights have been violated.
But not in Kansas?
I am not aware of any as of right now.
Asked and answered several times. Any other questions? Representative Probst.
Thank you, Mr. Chair. So let's dive into this a little further about why there aren't cases in Kansas. The Janus decision, if I remember correctly from last year's testimony, is that comes from a state that has compulsory membership. And Kansas does not have that. Is that correct?
The first part of the Janus decision regarding compulsory dues or fees, but the second part is what we are addressing here today, which is that opt-in, which Kansas does have. Does not have to the sufficiency of what the Supreme Court laid out in the Janus versus AFSCME, that evidence, that clear and compelling evidence of affirmative consent, as Justice Alito put it.
Any other questions? Any online? Seeing none, thank you, sir. Stick around in case we have other questions later or ask for clarification.
Thank you very much.
Thank you. Next up is Dave Travert, Kansas Policy Institute. Welcome back to committee, Dave.
Thank you, Mr. Chairman, members of the committee. Again, for the record, Dave Travert, Kansas Policy Institute. We're here with strong support for the bill because it's about one of the founding principles of our country. First Amendment right to free speech and freedom of association. That's in no way a negative connotation or implication against unions. It is simply about protecting the individual rights and to bring our state statutes into compliance with a U.S. Supreme Court decision. And I'm going to focus my remarks mostly on why this legislation is necessary in Kansas. Constitutional rights are not subject to a calendar. You don't have the right to free speech today, but not next week, and then again the week after. They are absolute, constant, and they must be in that case. Now, Kansas does have a right to work law, but the law in Kansas restricts employees' rights to leave whenever they wish, and that clearly has to be corrected. We've heard from Mr. Vernuccio that some rights are restricted in Kansas. The KNEA application says you have to, you can only get out in August. There's also a state statute, 75-5501, that says public employees' dues authorizations must be in effect for at least 100 days. Your constitutional right to leave cannot be restricted for 1 day, let alone 180 days. This is also something, just for your edification, because constitutional issues trump, but this is something that is not only strongly supported by your constituents, but also strongly supported by the union members who were in, or I should say the government employee members, government employees who participated in our survey last year. 67% of all constituents said, yes, this should be done, and only 18% said no. Among government employees, it was 67-14 in favor of having this right. Now, we know that there's restrictions. We know what the constitutional law is. That's not questioned. And so we would ask you to recommend 2354 favorably for passage and give employees their constitutional rights without having to sue you for them, and also bring our state laws into compliance with the constitutional, with the Supreme Court decision in Janus. And with that, I'll be happy to stand for questions.
Any question for Mr. Travert? Any online? Seeing none. Thank you, sir. Next up, Eric Stafford, Kansas Chamber.
Good afternoon, Mr. Chairman and members of the committee. My name is Eric Stafford, here on behalf of the Kansas Chamber of Commerce in support of House Bill 2354. I think Dave Mr. Traubert summarized the issue pretty well. I'm going back and forth here, sorry, on some tabs. First, I'll just start with the question from Representative Highland on didn't we pass something like this a few years ago, back in 2013. The state did pass. I'm going blank on the bill number. It started as House Bill 2023. I can't remember what it ultimately became. 2023 became a work comp bill dealing with, I think, first responders by the end of the time that it was enacted, enrolled, and signed by Governor Brownback. But the original version that did become law, and another bill number that I can't track down yet, House Bill 2023, prohibited professional and public employee organizations from using paycheck deductions for political activities. So it was limited to using dues for political purposes and deductions for political purposes. This is separate, allowing individuals to cease the payment of dues when they so choose. So that's the difference between what passed in 2013 and the bill that's before you today. So, but overall, in support of this, there's Supreme Court ruling on this that establishes free speech rights. You have a quote in our testimony there from Justice Alito that states and public sector unions may no longer extract agency fees from non-consenting employees as it violated their constitutional right to free speech and association. So be happy to answer any questions at the appropriate time, and thank you for the opportunity to speak in support of House Bill 2354.
Thank you, sir. Any questions? Seeing none. Thanks.
Thank you.
Rebecca Becker online or here in person? We'll skip over her for now. Gary Siegel.
Good afternoon, Mr. Chairman and members of the committee. My name is Gary Siegel. I have been the executive director of the Kansas Association of American Educators for the past 10 years. I'm providing this information today to testify in support of House Bill 2354. My perspective also includes 33 years as a teacher and coach at Riley County High School, Riley, Kansas. The Kansas Association of American Educators is a non-union educator association. It is a professional association that provides benefits and services to educators such as liability coverage and professional development opportunities. KNA is not a union and does not bargain contracts for teachers. We believe teachers should be allowed to join the union at any time of year, and we believe they should be allowed to leave the union at any time of the year. Polling shows that 85% of the teachers agree with this position, as they want the freedom to do as they see fit. KNA's policy is to do just that. We allow educators to join at any time, and we allow them to close their membership at any time during the year. The problem is many teachers aren't allowed to do that in the union. In my work with KNA, I'm finding there are some districts in Kansas that actually do let union members out during the school year, but other districts keep strictly to whatever opt-out dates they have set up. In one district, it may be August 1st to August 31st. In another district, it may be that you have to get out by August 10th. In another district, it may be that you have to be out by August 31st. The challenge is for these union members to wanting to end their membership to find the applicable dates for their district, and they should they fail to meet this arbitrary deadline, they are then left with paying hundreds of dollars in membership dues that they may not be interested in paying and have to wait until the next opt-out period. When I first became the executive director, I met a teacher who was a member of the union and wanted to join our association. She checked with her local, was assured she could stop her membership, then joined KNA, paying the entire yearly membership cost. At the end of September, she noticed in her pay stub that the union was still continuing to draw out membership dues. She checked back with her local and was told she had requested to leave too late and therefore couldn't end her membership until the end of the school year. She wrote me an email asking if there was any way that she could stop her membership with us because she didn't need membership in both associations. As a new employee, I called my national executive director and he said, give her her money back. I'll never forget it. As a new employee of KNA, it told me that this teacher was more important than her money. I've had other educators come to me frustrated that they want to leave the union but have been unable. KNA is an example of a professional association that is able to respect the wishes of our members by allowing them to end their membership at any time. We should respect our outstanding educators here in Kansas and make it easier for them to know their options and easier for them to exercise their rights. House Bill 2354 will do just that. Thank you for your time. I'm happy to answer any questions that you have.
Thank you. Any questions? Seeing none, thank you. Elizabeth Patton, are you online?
I am. Can you hear me?
Yeah.
Great. Good afternoon. My name is Elizabeth Patton, State Director for AFP Kansas. My testimony is brief today because we believe the bill we are discussing is straightforward. Americans for Prosperity is advancing employment policy that empowers people to earn success, contribute to their communities, and live meaningful lives. We believe the dignity of work, choice to pursue the profession of one's choice, and voluntary association are key to a free and thriving labor market. And as you've heard, Kansas employees have enjoyed freedom of association for decades through state law. But again, as you already have heard, in June of 2018, with the Supreme Court decision in Janus, this is a First Amendment right for all public employees in the United States. And we are asking that you support this bill to help ensure that the state of Kansas is in full compliance with First Amendment constitutional rights of its public employees. Again, each worker should be given an opportunity to affirmatively consent to paying a union before government facilitates unions in collecting payments, either directly or indirectly. And so essentially, just as unions change stances and performance at any time, so too do we believe workers should be able to decide that a union is no longer serving their interest at any time. And that is also what the Supreme Court has said. So making any delays in exercising First Amendment rights is indeed troublesome. And we believe this is a great opportunity for us to make sure we are protecting our First Amendment rights in Kansas to the fullest extent and in full compliance with the Supreme Court decision. In their decision, the Supreme Court said that by agreeing to pay, non-members are waiving First Amendment rights, and such a waiver cannot be presumed. And we feel like that is such an important phrase, and we ask that we become fully compliant with this decision, and we not presume anything about people's First Amendment rights. And for these reasons, ask that you support hardworking public employees and give them the ability to opt in and opt out through this law today. Thank you, and I'd be happy to stand for questions.
Thank you. Any questions for the conferee? Representative Probst.
Thank you, Mr. Chair. Thank you for testifying today. I've listened to this testimony and I'm still struggling, and I really hope someone can explain to me how we've been 3 years since Janus and have yet to have a suit in Kansas. So as I understand it, we don't have compulsory membership. So I really need someone to explain to me how in Kansas someone's constitutional rights are being violated by voluntarily joining a union.
I would be
Elizabeth,
happy
do you
to.
want to take that, or do you want to defer to anybody else?
I'd be happy to defer to probably Vincent or Dave in this case, look at this from that perspective, but specifically Vinny. But I just want to also say that just because a lawsuit hasn't been brought in the amount of time doesn't mean that it is okay for our state laws to be out of compliance with a Supreme Court decision. And I do think that puts our state at risk. And no matter when it comes, and to Chairman Tarwater's point earlier, this is a preemptive opportunity for our state to be in compliance and avoid a lawsuit. That would be an unnecessary use of taxpayer dollars, and we have an opportunity to do this today and in this session. And I think that given the opportunity to protect First Amendment rights, we should always err on the side of doing that as opposed to not. And I would happy to yield to one of the other conferees for more on that.
Yeah, I'm happy to also address Elizabeth. I think you're Ms. Patton. I think you're absolutely correct. Kansas should not wait to be sued before taking action. That is definitely not a good use of taxpayer dollars. The decision by the Supreme Court, it spells out what should be done. It's clear. There are multiple lawsuits in other states. Public employees whose rights are being violated are bringing lawsuits. Once again, Kansas has been lucky in the regard that they have not seen a lawsuit. I don't think that the state should wait until a lawsuit is brought to start respecting the First Amendment of public employees throughout the state. Yes, Kansas does not have compulsory membership for unions, and neither does any other state, with or without a right to work law, even before Janus. No state, no union could compel an employee to join. The difference was that before the Janus decision in non-right to work states, unions could force public employees to pay them. But even putting that aside, that was only the first part of Janus, where the state of Kansas and many other states are still violating the First Amendment freedom of association rights of public employees. Is that second part of Janus, that clear and compelling evidence, that direct, that waiver that cannot be presumed, and that trapping public employees into paying dues until a certain time of year. So they only have a narrow window to get out, or they have to wait another year until they can exercise those rights. Those are violations of the First Amendment rights. That is what Justice Alito meant when he said that clear and compelling evidence of affirmative consent. And that is what Kansas is looking at doing today to make sure those rights are protected in state code. And I'm happy to clarify if there are any further questions on the issue.
Have a follow-up? No. Any other questions? Representative Shu.
Thank you, Mr. Chair. If I'm understanding the intent of this correctly, it's basically to get us in compliance with the Supreme Court decision. Is that correct?
Yes, I believe that's the point.
I guess I would ask the conferees if they would also support, due to the gay marriage Supreme Court decision, if they would also support that to allow Kansas statute to get in compliance with the Supreme Court decision there.
I don't believe that's contained in this bill, but if somebody wants to take a stab at it, you're welcome. Any other questions? Seeing none. Thank you. Rebecca Becker, one last call for you. Is there anyone else in the room or online that wants to testify as a proponent in HB 2354? Seeing none, we'll go ahead and close the proponent section of this hearing, and then we will open the opponent section. I believe Jake Miller is here in the room. Mr. Miller, thank you for coming today and welcome to committee.
Thank you, Mr. Chair and members of the committee. I hope you're having a good day. You guys have my written testimony, and I make a lot of legal arguments in there. I'll start out. I'm Jake Miller. I'm the Executive Director of the Working Kansas Alliance. And on the other part of my life, I actually practice labor and employment law in Kansas City, Missouri, where I represent both private and public sector workers. I deal with Janus all the time. And in that testimony, I talked to you about how Janus does not say what we're getting told here today that it says. And I have so much belief in that. I apologize to anyone else who's an attorney on the committee, but I know Representative Ralph is, and I know Representative Miller is. I'd love for these two to sit down. They're from opposite parties and discuss the decision, because I still don't know. None of the proponents told us where in the decision it says that we have to have this. Kansas complied with the Janus decision in 1958 when Mr. Janus, the plaintiff in the bill, was a little kid. There's nothing here that says we need to do this. There's just no proof to it. To back that up, 3 years ago, we had a hearing on Senate Bill 175, which was the original bill number for this bill. Mr. Trabert and KPI had a press conference after it where they announced a free legal defense fund for any worker who wanted to break their union in Kansas. Over 3 years, they haven't had one client who comes for free legal defense work to take this bill to the courts to show us why we need it. We're offering they're offering, not me, free legal services on this, and they can't get a client. So to me, this is a waste of the committee's time. Kansas already complies with Janus. This is not something that we need. It's burdensome. If you look at the opponent testimony, not only are labor unions against this, but management is. Management of school districts and local government entities. This is going to cost local governments a lot of money to comply with. This bill forces local governments to follow up with every single labor union they have. You have testimony from an elected official in Wyandotte County that has 13 bargaining units. If they were, from our understanding from the unified government, if they were to follow up with every worker via email, as this bill forces them to, they'd have to hire another staff person. I mean, at the end of the day, this is a tax increase bill. I mean, this bill is going to cost local governments money when budgets are already tight. It's attacking workers that have worked 15-hour days last week to keep the lights on, that have plowed the roads when it was sub-zero temperatures, firefighters, police officers that fought during COVID. We keep going to this point of K&EA and teachers, K&EA and teachers. Section 4 of this bill Section 4D, to be precise, talks about public employees in general. We want to talk about, when we can and we will talk about teachers all day long, but just remember, you're going after cops, you're going after firefighters, corrections officers, electrical workers, snowplow drivers, and everyone else. This is every public employee in Kansas. And I'll take any questions if necessary.
Any questions for the Comfrey Representative Miller?
Well, first I want to make the record clear that although Representative Ralph and I are different parties, we almost never disagree when it comes to vote. Mr. Miller, did you listen closely to the proponent's testimony?
Yes, I did.
There were a lot of friends of public employees that testified that I wasn't able to identify any of them as a public employee. Were you?
I'm sorry, say that again.
Were any of the proponents of this bill speaking in behalf of public employees' rights, a public employee?
None of those that orally testified. I did see, I think, 2 or 3 proponent written testimony from a couple, but that was it that I saw.
Thank you, because I've yet to hear from, and I represent a lot of public employees, I've yet to hear any of them endorse this bill. Thank you, Mr. Chairman.
And to back that up, we have many public employees that offered written opponent testimony.
Any further questions? No, Representative Williams and then Probst.
Thank you, Mr. Chairman. So are employers, are they required to deduct union dues?
No.
No, so that Wyandotte, unified government, they could say, you're going to have to pay your union dues personally, through check, through money order, through debit, through credit card.
But that's not what they're testifying on.
Right. But what I'm saying is that they're saying that it's undue burden for them to have to follow up on it or to have options for their employees. But I just asked if they were required to do that.
Well,
They're not required to take the deduction, are they?
But the bill requires them to follow up on the authorization.
Right, I guess.
So they still the requirement.
My question was employers. My question, sincere question is, are employers, must they be the one to collect the dues? Does it have to be a deduction? Can individual employees pay directly to the union?
Yes, but this bill doesn't touch dues deductions.
Exactly. I'm just making, just asking a question that those employers could say, we are no longer going to provide deductions because it's too much of an hassle. And then they could go directly to the union. But my second question would be to you is, for those individuals, those public employees, it sounds like 85% of teachers would be in favor of this. And one of the proponent written testimony was from a teacher. And they could not get out of it. And we heard another individual testify on behalf of someone else, anecdotally. What would be the harm of allowing people that option for that individual other than Wyandotte County says it's too many people?
Well, I'll be honest with you. Of the unions that are members of my organization and the unions that I work with, from my knowledge, when a member comes and requests that they be dropped, they're dropped. It's simple as that. These are private contracts, and most of the time, unions don't want you to have to stay in if you don't really want to stay in. The reason those authorization cards read that way is because they're mimicked after federal law, and that's how every employer in the nation has them. On private sector employees, there's a portion called BEC, and BEC notices, and those BEC notices have to be on authorization cards that give those windows. So all they're trying to do is comply with that. If you were a member of a union and you wanted to drop and you called your local hall, the unions I know of drop. They say, fine, you can drop. I can't speak on specific instances for those 2 teachers that provided written testimony, but from the ones that I know of, that's why there hasn't been a court case, because they're dropped. There's no legal argument there.
Would you say that teachers in the state of Kansas make up the majority of employees that have an option to join a union? Is that the largest pool of public employees in Kansas?
Of public employees, yes. I guess you could say. I mean,
if teachers are the largest percentage of public employees in Kansas, and those school districts predominantly have one or perhaps two unions, it wouldn't be cumbersome for the majority of employers in Kansas. Thank you.
Representative Probst.
Thank you, Mr. Chair. To the previous representative's point, I think that the burden comes, and based on an email I have here from an HR person with the county, the burden comes in this statement that's included. We spent a lot of time talking about being able to get out of a union at a certain time, but I think we're glossing over the fact that there's a statement that has to be presented and followed up on, and somebody has to collect that information and make sure that that's been addressed. And if I understand that correctly, that's where the burden's going to come. But my question to you is, we heard from the proponent testimony, and they didn't directly answer my question about how these First Amendment rights are being violated if someone has an option to join a union, as they do in Kansas. But I'd like to hear your perspective on what the Janus case says and what it is asking states to do.
You heard the term agency fees in proponent testimony, and agency fees is an aspect that some unions used to charge. It's a little different in Kansas than the rest of the country, so I'm giving you a broad view for some sort of union representation. Basically, what Janus did is they made every public sector employee in the nation right to work. That is agency fees, and all that comes into effect when it comes to right to work. Again, Kansas has been right to work since 1958. I mean, at the end of the day, we've complied for way before my lifetime, actually before my dad was born. So this, in a roundabout summary, it made every public sector employee a right to work employee, which is why it had no impact on Kansas. It had impact on Mr. Janus's state in Illinois and California and states that weren't right to work. It didn't have an impact in Kansas.
Follow up.
And you said we've been right to work since 1958, right?
I believe it was 58. I know it was in the 50s.
And because we're a right to work state, we're already in compliance with Janus. Is that your understanding?
Yes, that's why there was no impact on it.
And so this bill, if it comes out of this committee and it's successful, it's duplicitous. It's already, it's overstepping, it's overreaching government to address, to create legislation that's already addressed by prior legislation.
True. Absolutely correct. The easiest way I can put this is all the proponents are saying you must do this to comply. In reality, I'll be upfront with you. You could do it. You could. No reason you can't. You're the legislature. You can do whatever you want. You don't need to. You don't have to. You must not. You don't have, any of that. But the problem I think you're going to run into, if that is the case when you talk about overburdensome, I speak to it in my testimony a little bit. I think that there's a very good equal protection case here that you could see go to the courts on the flip side. Because you're targeting public sector unions, you're targeting these organizations, and you're not treating it across the board. I think that there's a very good equal protection argument. And as much as we're talking about the First Amendment, there's a First Amendment right of association here that we're throwing out the window if this bill's passed. So I think you're going to see a court case in that case. So.
You mentioned previously in your testimony that the proponents of this bill had established a legal defense fund, right? And they put out a challenge to Kansans. If you want to challenge Kansas, you want to challenge this, we'll pay for your legal fees. Is that right?
I don't know the particulars on it. There was a press conference on the first floor, and there was articles and press releases released by Kansas Policy Institute on it that it was a worker defense fund.
That was my thinking, because I thought that the legal arm of KPI would most definitely have tried to find somebody to initiate a lawsuit if there was legal standing in Kansas to bring a suit. Thank you.
Thank you. Any other questions? Seeing none. Thank you, sir. Mark DeSetti, You're up next. I believe you're online. I saw you earlier.
Yes, Mr. Chairman, can you hear me and see me? I guess I can see myself. Can you hear me, Mr. Chairman?
Yes.
Yes, okay. Thank you for the opportunity to testify as opposition to this bill. I represent the Kansas National Education Association, and let me say up front that unlike some in this room, I am not an attorney, so I want to focus on a couple of things that came up. First of all, this whole idea of it has to be done because we're protecting a First Amendment right. I want to point out in the I just want to read to you what the First Amendment says so that we're all on the same page here. The First Amendment to the United States Constitution says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for redress of grievances. And I want to focus on that last piece of it, the right of the people peaceably to assemble and to petition the government for redress of grievances. When the Constitution was written, it was written after a time when we had attempted peaceably to assemble and petition the government for redress of grievances. What was protected in the First Amendment is not the right not to do something. You can always not do something. It was the right to do something. And in essence, when you join a union, or when you join anything, when you join a bowling league, when you join anything, you are asserting your First Amendment right peaceably to assemble. And specifically, when you join a union, you are asserting your First Amendment right to assemble and to petition the government for a redress of grievances, whether that's a school board in our case, or the legislature, or a county commission. That's what a union is about. It's about freedom to assemble peaceably to petition the government. By saying I waive my First Amendment right to refrain from union membership is a twisted version of the First Amendment. In reality, when you join, you are asserting your First Amendment right to assemble and petition the government. We don't say, for example, that if I choose to go to church, I have waived my right not to go to church. If I choose to speak out on a political issue, I have not waived my right to not speak. No, these are things that you can assert to do to protect you. You always have the right not to speak out. You have the right not to go to church. You're not waiving that right by going to church. I want to point out that as Jake pointed out, there is no Janus application here. Janus was about compulsory, if you will, fees paid by non-members to unions for representation. And Kansas does not have those fees. They're a right-to-work state. We've never had them. So no one has ever had to pay to a union that didn't assert their First Amendment right to join that union and pay those dues. What we further do in this bill is we set up a system to, in essence, I can't put it another way, to harass people who want to join the union. We're going to essentially drop their membership for them every year, make them re-sign up to pay their dues, and then tell them, first we're going to tell them, you don't have to join the union. And then we're going to tell them, are you sure you wanted to join the union? When do we tell our employees, you don't have to give to the United Way? Are you sure you want to give to the United Way through payroll deduction? It's just, and nobody is going to say, nobody under this bill says, this person just dropped their membership. No one has to call them up and get them to say, and ask them, are you sure you wanted to drop your membership? Apparently, you're right in dropping, but you err in joining through this bill. No, when you join, you are asserting your First Amendment rights under the United States Constitution to peaceably assemble and petition the government for a redress of grievances. Frankly, we don't look at, and the issue of when you can drop the dues is a contract issue, and Mr. Miller put that talked about that clearly. Our membership form does have the month of August as the drop. It also says on our membership form, and Mr. Venuccio was not reading our current membership form, he was reading an outdated form. After it talks about the drop date, which is the month of August, I understand that this agreement is voluntary, not a condition of employment. I have the legal right to refuse membership without suffering any reprisal. It says that right on the form. In addition to which, school districts generally have a separate document that they use for dues deduction for any purpose, whether that be United Way or dues to an organization and so on. So frankly, we think that this legislation is unnecessary. It twists in that statement that must be signed the reality of the United States Constitution and the First Amendment, and is simply here to harass union members and to, in the eyes of its proponents, to block union membership and discourage people from joining unions. We don't think that the government should be in the business of telling people that they should or should not join a union. That is the choice of the individual, and we think it should rest there with that individual. With that, Mr. Chairman, I would stand for questions.
Are there any questions, committee? Representative Clayton.
Thank you, Mr. Chair, and thank you for being here, Mr. Tassetti. I have a question, and this might apply more broadly to the entire bill and not just to teachers, so please do bear with me here. But I was reading through in some of the written testimony from the Fraternal Order of Police, and there was a mention that this would jeopardize their benefits, which, you know, as one who backs the blue, I tend to not want to do that ever. Does this jeopardize teacher benefits, and can you explain to me how that would work?
I don't know that it would jeopardize teacher, benefits are negotiated. We have collective bargaining. As long as we have collective bargaining and still have organizations to represent teachers and assist them in bargaining, benefits will be there. Obviously, when we put up roadblocks to block union membership, when we deliberately enact legislation to depress union membership, the weaker unions become, the more likely it is that benefits those employees and salaries for those employees and working conditions will deteriorate. I don't think that hurt benefits. I got a little spin there. I don't know if I was dropped off or not. I don't know that it would directly hurt benefits, but it has potential to do so if the goal is to get rid of public sector unions. It will absolutely do that in the end. I'm sorry, Mr. Chairman, can I still be heard? My computer seems weird here.
Yes, sir, you were in and out a little bit, but then your video shut down and we could hear you loud and clear. Representative Clayton has a follow-up.
So my video shut down. Thank you, sir.
Thank you. And no, I just wanted to thank you for your testimony and extend my gratitude to the teachers. Without them, I would not be able to be here in committee today. So thank you, and thank all those essential workers. Thank you, Mr. Chair.
Representative Curtis.
Thank you, Mr. Chairman, and Mr. Tassetti, thank you for your testimony today. So just something that you said to me just kind of resonated, and I just want to kind of go back through that, and that is that, you know, when you join a union, it's a commitment, just like when I sign up for AAA or when I sign up for OnStar. And those commitments are usually for a year. And I usually mark on my calendar when that renewal is, in case I decide that it's not worth my investment to continue with that, then I have the opportunity to stop it. So, I mean, we're not talking about something that is much different, correct? I mean, we all do that. We all, join various groups or sign up for various services, and we have to monitor ourselves, when that time comes, if we no longer want to do that. Is that not how that works today?
Well, I think that's correct. I think of my own case when I decided that I wasn't using a gym membership and wanted out, and I went in to drop, but I had missed the deadline and I had to pay a second year of membership. I didn't miss it the second time, I can tell you that. And the same is true on almost on so many things that we have today in life. Subscriptions to magazines are run this way, or our streaming services are run this way. I keep seeing the Kansas City Star wanting me to get a subscription, and it says, oh, by the way, when you do this, it's ongoing. It does not stop.
You have to opt out then at that point, right?
Windows, but it is what it is. It's a contract issue you enter in when you join the gym or when you get a subscription.
Yeah, thank you. I appreciate that. I think I see it as you do. This is just a way to try to reduce membership in our unions. So thank you very much.
Any further questions? Mark, you said that this has to do with basic only fees. What about in the ruling where it says neither an agency fee nor any other payment to the union may be deducted when someone opts out?
I'm sorry, Mr. Chairman, I'm not certain what you're referring to directly there. Is it something
your testimony was that the Janus decision really only had to do with fees, but I'm reading it, and of course I'm not a lawyer either, so we're in the same boat here, but it says neither an agency fee nor any other payments to the union may be deducted from a non-member's wages. And so once somebody decides they are a non-member, we can no longer deduct. And then it says that they must be, in order to be effective, the waiver must, if you have a waiver, must be freely given and shown by clear and compelling evidence. So what am I reading that's different?
I think I am, as you said, Mr. Chairman, in the same boat. I'm not an attorney, but what the window is a contract issue. You enter into a contract. What Janus was about, Janus was brought by an individual who was required to pay fees, and they're called different things. They're called agency fees, representation fees. In some cases, I think they were even full amount of dues. In many cases, they are something less than dues, or were when they were allowed. I believe that refers to those. That's what the case was about, and refer to one of the attorneys in the room, but my understanding was, well, the case was about agency fee and representation fee that non-union members were compelled to pay, that has never been allowed in the state of Kansas.
Looks like Jake Miller is coming to our rescue here.
So will you clarify your question again? It was on the agency fees.
So I thought he had said that the Janus was strictly about agency fees and not about dues, but it appears that the ruling or the opinion states that it can't be.
So.
Or any other payments. They can't take any payments once they opt out.
Yes, the ruling was about dues, in that it was a union's First Amendment right to not have to pay dues that were then subject to other expenses you weren't in favor of. This bill does nothing with dues, has absolutely nothing to do with dues. Kansas has always been where we didn't charge these agency fees, which is what you're seeing about those dues. When we talk about the First Amendment right, they're saying in the opinion that the First Amendment rights that are being violated are of those that have to pay dues to a union that are then spending those dues monies on things I don't agree with. The reason Janus doesn't apply in Kansas is we don't charge non-members dues. We never have. Well, we did before 1958, but we haven't since then. So it didn't apply because those First Amendment rights on those dues aren't of question here, in a simple put.
Okay, thank you. Seeing no further questions, is there anyone else in the room that wants to testify as an opponent, or is there anyone online that wants to testify as an opponent? I'm showing a few other written onlys here that you have in your email. Seeing none, we'll close the opponent section of the bill hearing. Committee, the other item on the agenda is to discuss previous bills. And I'm going to try to see if we can get the 3 bills of the Secretary of State out. And then maybe one other one if we can get to it. Then the 4th bill is HB 2231, which would be the Amazon bill that we'll discuss if we have time. With that, I'll open the discussion on HB 2297. Representative Long.
Thank you, Mr. Chairman. I move we pass out HB 2297, favorable for passage.
We have a second. Seconded by Representative Tarwater. Charles, can you give us a quick overview of HB 2297?
Certainly, Chairman. Chairman, members of the committee, HB 2297, as the committee will recall, is from the Secretary of State. It pertains to certain publishing laws that the Secretary of State deals with. The bill permits the Secretary to obtain publishing services in the commercial market. It removes requirements that the Secretary set the prices for its publications by the adoption of rules and regulations. It permits publication of proposed amendments to the Kansas Constitution in a newspaper of general circulation in the county in circumstances where there's no newspaper that's published in that county. Those are the primary things the bill does.
Thank you. Any questions for the reviser? Any discussion on the bill or any amendments? Seeing none. Representative, you may close.
I close.
Committee, you've heard the motion. All in favor say aye. All against say no. Motion passes. Committee, I'll draw your attention to HB 2298. Representative Long.
Thank you, Mr. Chairman. I move we pass out HB 2298, favorable for passage.
Seconded by Representative Hoffman. We'll open, or we'll talk to Chuck first, or Charles first, in a discussion of what the bill does.
Thank you, Chairman, members of the committee. House Bill 2298, again, is a bill from the Secretary of State. It updates certain service of process provisions associated with that office. First of all, it addresses some process provisions, service of process provisions for non-residents who operate motor vehicles in Kansas. Provides that service may be made on the Secretary for those non-resident drivers. and updates those provisions. Another thing the bill does is it adds domestic and foreign limited liability partnerships to the provisions that govern service of process on business entities. And that is what the bill does.
Any questions for the revisor? Any amendments? Seeing none. Any other discussions? Seeing none, Representative, you may close.
Thank you, Mr. Chairman. I close.
Committee, you've heard the motion, seconded by Representative Hoffman. All in favor, say aye. All against, say no. Motion passes. Committee, I'll draw your attention to HB 2391. Representative Long.
Thank you, Mr. Chairman. I move we pass out HB 2391, favorable for passage.
Seconded by Representative Johnson. Get a discussion on what the bill does from Charles Reimer.
Thank you, Chairman, members of the committee. House Bill 2391, again, a bill from the Secretary of State, primarily provides for a biennial filing requirement and fee requirements for business entities. These changes are effective January 1st, 2023. The bill also does a few other things, technical corrections to some sections. It clarifies the law with regards to the name of a professional association. It repeals some statutes dealing with blanket music licenses, and also provides for electronic signatures to be used when filing documents with the Secretary of State, and some other provisions, but those are the primary things that the bill does.
Any questions for the revisor? Seeing none, for discussion on the bill, Representative Kessler.
Thank you, Mr. Chair. I have an amendment.
Charles, could you get that emailed?
Yes, Chairman, I'll do so right now.
Representative Kessler, you want to just explain what it does while he's emailing it out?
Thank you, Chair. Yes. This is actually a pretty simple deal. This amendment is in reference to the biennial filing reports for businesses. As the bill is written, if your business was initiated on an odd year, you file on an odd year. If it's initiated in an even year, you file on an even year. And doing it biannually is to help the businesses out. My suggestion here, my amendment here covers that if you own multiple entities, and regardless of the year that you open those entities, you can file all of your entities together every other year.
So when you worked on this amendment, did you work on it with the Secretary of State's office?
Yes, they were very helpful with this. They were actually for this 100%.
Okay, we'll take your word on it. Well, they're here.
They said a lot of other things too. I mean, you know, just kidding.
Charles, did he explain the amendment correctly, or do you want to add anything?
No, Chairman, I don't have anything to add.
Has that been circulated?
Chairman, I have sent it. I don't know if it's been, I haven't received it back yet.
Cindy, you forwarded that to the committee? Okay. Sometimes things take a minute or two. Seeing some indication that some people are receiving it. Does anybody want to take a moment to review it before we vote on it? Representative Probst says yes, so we'll give you a minute. Any discussion on the amendment while they're looking it over? Representative Johnson.
Thank you, Mr. Chair, and I would say thanks to the maker of the motion. A number of us had talked about whether we could make it simpler to be able to file if you've got 2 or 3 entities at one time rather than continuing to file annually because your start year was different. So I appreciate the work offline to address it. Thank you, Mr. Chair.
The amendment, by the way, is seconded by Representative Long. Everybody have a chance to, Representative Carpenter.
Thank you, Mr. Chair, committee. So how do you decide which year, the odd number or the even number? Do we get a choice?
Representative Kessler or Charles? Let's go with Charles.
Chairman, the specific language which was provided by the Secretary of State is that this ability to file at one time the reports for more than one limited liability company or series is dependent on all reports must be filed in the first year. A biennial report is due under this law in an odd number of years thereafter. So that's a specific language that goes to when these reports may be filed.
So what does that mean?
Thank you.
I was looking at your face.
Chairman, I would interpret that as to mean that whenever that these reports must be filed the first year they're due, whenever that is, and then an odd number of years thereafter. So typically under the provision, under the changes in this bill, you know, it depends on when the formation document was filed. This specifically provides for you need to file it the first year it's due, and then an odd number of years thereafter. So, so it's a little bit different, but I guess the Secretary of State wanted these filed in odd numbered years.
Okay, can someone from the Secretary of State's office provide any clarity on that? It seems that you file them all in like 2021, but then you'd have to file them again in 22 and then every other year thereafter, but let's make sure.
Mr. Chairman, I'm Katie Copal, Deputy Assistant Secretary of State for Communications and Policy. If you recall, the biannual filing provisions of this bill go into effect January 1, 2023. So then they would have to do it in the year 2023, and so that would place them in the odd years thereafter.
Okay, and then if they did it in 2024, they would be in the even number.
In the even years, yes, sir.
So it's just an election you make one year, and then all your filings are that every other year.
I'm going to defer that specific question to our Director of Business Services, just because I don't want to make a mistake, if you will let me do that.
No problem, no problem.
Good afternoon, Mr. Chairman. I'm Jennifer Cook, Deputy Assistant for Business Services. So when we drafted this, with the delayed effective date, we decided just to start it in 2023. So just to set it for that first year, they start filing, and then they would file in every odd year.
Okay, Representative Johnson.
Thank you, Mr. Chair. And I had a similar question. Just reading this, it references the odd years, but I don't see the other. And as I read it, it seems like it says I can do it whenever my first year is due, but then after that it's in the odd years. Am I reading it wrong, or is that how it would work?
The intent and the way we believe we structured it is that if you, let's say you just have one LLC and you formed your LLC in an even numbered year, then you would file it, excuse me, in an even numbered year after the start of the biennial filing. If you file in an odd numbered year, you do the same. For those who want to file multiple, we didn't want them to try and have to think, well, maybe I formed some businesses in an odd numbered year and some businesses in an even numbered year. So we just decided to start with odd and just kind of leave it at that. And that way, folks weren't trying to figure out if they had businesses formed in 2 different years when to file. So it was really trying to make it just simpler and cleaner for the customer and for us in terms of administrating that.
Representative Johnson.
Thank you, Mr. Chair. So then if I understand, if I formed my entity in an even numbered year, I would file that starting in 2024 and every positive, even year thereafter. If I had an odd-numbered year or multiple entities, I would file them in the odd-numbered year and odd-numbered years thereafter.
That is correct.
Thank you. Thank you, Mr. Chair.
Okay, so not to confuse things further, but this changes everyone to the odd-numbered years, always, or just when you make that election?
Mr. Chairman, this would change those who are filing for multiple entities.
Okay.
So if you're
Okay.
just a single entity, you'd be an even, odd, odd. If you're multiple entities, we just put you in 1 year to try and make it simpler so you weren't trying to sort out which year to file in.
Perfect, okay, thank you. Any further discussion on the amendment? Representative Johnson.
Thank you. And I believe if I chose to file my odds and evens continually as odds and evens, I'm fine to do that. This just gives me the additional flexibility if I want to put them all together in the odd-numbered years, I can.
Yes, sir, that's correct.
Thank you.
Any other questions on the amendment? Seeing none, Representative, you may close.
Chairman?
Oh, yes, sir.
Yeah, I was just, actually with all these amendments, I'm hoping that the committee will give the revisor's office some discretion just to change a little bit of the wording. For example, our proofing department doesn't like the word must, so we might change that to shall. Just things like that, technical, non-substantive things or grammar, that type of thing. If the committee would give us discretion to do that.
Is that okay with the maker of the amendment?
Yes, Mr. Chair.
Second? Yes. No problem, sir. Thanks for pointing that out. Representative, you can close.
Thank you, Mr. Chair. With that, I close.
Okay, committee, you've heard the motion. Seconded by Representative Long. All in favor of the motion, say aye. All against, say no. Motion passes. Any further discussion on this bill? Any other amendments? Anyone online? Okay. Seeing none, Representative Long, you may close.
Thank you, Mr. Chairman. I move we pass out HB 2391, favorable for passage as amended.
Committee, you've heard the motion. All in favor, say aye. All against, say no. Okay, we're going to see if we can try to just discuss HB 2231. Charles, would you be able to pull that up and explain it to us, or are we getting ahead of ourselves here?
Just one moment, Chairman, let me pull that up.
Okay.
Chairman, members of the committee, House Bill 2231, as the committee may recall, concerns the crime of conducting a pyramid promotional scheme. That's House Bill 2231. And the basically this was brought to clarify that crime. There are a number of changes in the definition. One of the key ideas is that there's an exception if the plan or operation does not cause inventory loading. This was, basically is what the bill does.
Any questions for the reviser before we get a motion? Seeing none, Representative Long for discussion on the bill.
Thank you, Mr. Chair. I move we pass out HB 2231, favorable for passage.
Anyone want to second that? Seconded by Representative Dodson. Discussion on this bill? Any amendments on this bill? Seeing none. Representative, you may close.
Thank you, Mr. Chair. I close.
Committee, you've heard the motion by Representative Long, second by Representative Dodson. All in favor say aye. Aye. All against say no. No. Ayes appear to have it. Ayes do have it. Motion passes. With that, committee, I need to make an announcement that we will be working on Friday. I think we made that announcement at the well. We still have some bills we've got to get out, and I plan to work the unemployment bill again tomorrow. Hopefully we can conclude that tomorrow, but if not, that will go into Friday. Either way, though, we will be voting on things on Friday, so if you need to go home, or if you already had plans to go somewhere else, just let us know, either Representative Clayton or I, and we'll get a replacement for you so that we make sure that we can have representation. With that, we'll adjourn. Thank you.